The meeting here is to go over 3 House bills that are candidates to be added to pending Senate bills, which are coming up in the committee either today or next Monday. And so what I would want to do is to go through the due diligence of looking at those bills as if they were standalones and to take motions on them, and then at the appropriate time go ahead and take a motion to amend them to the appropriate Senate bills. I know that Senator Mullis has graciously given permission for us to potentially use his SB 72 as a vehicle for House Bill 578, Chairman Weldon's bill, and I don't remember the number for Representative Chandler's bill. 534. So he's given permission on those, provided the committee's comfortable with that. So let's go through the due diligence of getting comfortable or not with those particular bills, and then we'll go ahead and what we'll do is we'll take those bills and we'll take a motion to add them as amendments to Senate Bill 72, again, with Senator Mullis's permission, and then we'll pass the whole thing as a substitute, again, if that's the will of the committee. So that's the contemplation. So I had hoped to have Representative Chandler go first, but she's not here yet. I know Chairman Weldon he has a client matter this morning that is unavoidable. I know Solicitor General C.R. Chisholm from Athens is going to go ahead and stand in for him, and that's fine. Representative Efstration is here on House Bill 430. It's undetermined as of this minute as to if the committee's comfortable with 430 as to what vehicle we will go ahead and use for 430. That's dependent on the Senate author to be named later being comfortable with that. But before we can even get to that, we have to go ahead and do the due diligence on 430. So let me ask Representative Efstration, if he would, to come on and give us the rundown on 430. I know this is a bill that's been worked on for a while. It went in late, and I know the subcommittee has reviewed it pretty thoroughly, and I think we've achieved consensus on it, he says, with hope. And then after Representative Efstration makes his brief but detailed presentation, then we'll have a you like that, and then we'll have the vice chair give a subcommittee report to the extent that he wants to, and then we'll go to questions and we'll go on from there. So, Representative Efstration.
Thank you, Mr. Chairman. First of all, I bring before you today a committee substitute to House Bill 430, LC 296551 Mr. Chairman, this bill incorporates many of the revisions that were discussed at subcommittee, and also, incorporates all of the, as passed out of subcommittee, along with an additional change, which I'll detail to address some concerns that were raised at the subcommittee hearing, and in an effort to build final consensus for the bill, which I believe we have here today. The bill provides a comprehensive revision and modernization of the state search and seizure laws that were last revised in 1966. Mr. Chairman, the bill expands on the definition of peace officer to allow for statewide legislation applying to district attorney and solicitor general investigators to apply for and execute search warrants. That the bill defines property to include both tangible and intangible, and as members of the committee might be aware, this is at issue due to recent Georgia Supreme Court case in Brundage determining that heat signatures are not tangible property and therefore not included in the law as far as a search warrant would apply, requesting a search warrant. It expands the ability of law enforcement to obtain search warrants to include kidnapped or persons also unlawfully restrained. So if there's a Garza issue concerning the false imprisonment rather than actually kidnapped, that would be included as well. Permits the use of crime scene video and audio recording by law enforcement during the execution of a lawful search or effecting a lawful arrest. Mr. Chairman, timely issue right now concerning procedure for body cameras on police officers. This bill would provide for those parameters. The bill requests to seal and delay disclosure of a search warrant in a time period that was discussed and negotiated at subcommittee. Originally, as written, it was 180 days. It's now been limited to 60 days with the possibility of applying for an additional 60 days. Also, in subcommittee, provides a motion to that a motion to suppress may be filed by a defendant agreed by a search and seizure action. The good faith exception, as it's been called in subcommittee and we're familiar with, is not part of or a component of this committee substitute. So existing law would continue as is currently regarding the suppressibility of a search that's subsequently determined to be based upon, Mr. Porter can comment on this, but based upon an inadequate search warrant. Would provide a comprehensive procedure for out-of-state law enforcement officers. This was amended. I'm sorry, was that done away with? What was? I'm sorry. Thank you. I'll strike what I just said. Should have been.
The original substitute, it was originally lines 434 through 501, and it set out a procedure for out-of-state officers to obtain search warrants in Georgia without the action of a Georgia officer, and by agreement and in the substitute that's before you, all of those lines have been removed. That entire code section has been removed. Frankly, Ms. Travers, I didn't know what to do with the actual code section number. It would have to be renumbered after that if you remove the entire code section. So I don't know what to do with that.
Where are you speaking of?
We're at in 6502 ERS, which was the subcommittee bill, the bill that was passed out of subcommittee. If you want to remove the procedure for out-of-state law enforcement to apply for a search warrant, you would remove lines 434 through 501.
It was done.
And it was
the
done in
last
substitute.
section, so there was no renumbering necessary.
But it's been done in the substitute. It's been all removed.
In 6551.
Right.
The bill also moves code sections relating to the procedure governing wiretaps, eavesdropping, and surveillance.
Let me interrupt you for 1 second,
Yes,
just to make sure the committee is completely clear. We are working off 6551 ERS?
Yes, sir.
Okay. Let's make sure we're all working off that 6551 ERS. Go ahead.
So the procedure does not, it's, as I've testified previously in committee, it's my position, I believe the position of, well, the bill is in no way a substantive change from current procedure for an existing criminal provisions for these matters of wiretaps. It defines district attorney for the purposes of federal law regarding electronic surveillance, creates a procedure for the installation and monitoring of GPS tracking devices, which is helpful following the Jones U.S. Supreme Court decision, redefines private place as meaning a place where there's a reasonable expectation of privacy consistent with the Fourth Amendment, provides for use of body cams and procedure, as I've discussed. The in language that was additionally negotiated in an effort to build consensus on the bill, district attorneys and solicitor general investigators would be permitted to obtain search warrants, but would not have general arrest powers as part of this legislation. And this would be effective July 1st of this year and apply to all offenses occurring on or after that date. And so in an effort to provide a summary, that's that is an overview of the bill. As mentioned, the issues that were the point of discussion have been addressed or removed as to the subcommittee hearing, and then further, the good faith issue was simply removed so that existing law would continue going forward. Mr. Porter is here today on his birthday to assist and provide any. Well, I wasn't going to say that part. And to assist me with any questions the committee might have. I'd be happy to answer any questions. Thank you, Mr. Chairman.
Thank you. I think we need to focus squarely on D.A. Porter's age right now.
I'll be happy to do that.
I remember seeing then candidate Porter in 1992 at various events in the greater Lawrenceville metropolitan area, and he's changed quite a bit. Just to make sure that's clear.
So was my son, who was with me.
Congratulations.
I'll be happy to answer any questions. I just want to inform the committee that this is a project that began essentially 2 years ago and really had a genesis in two different things. One was the growing concerns. One was the growing concerns over the government's ability to obtain private information of citizens, and the other was to bring the actual search warrant, traditional search warrant law, up to date with cases that have been decided by the Georgia Supreme Court. So what we did is we divided it into two articles. The first article deals with a lot of little things that repair, for instance, the idea of what is tangible and intangible. The Supreme Court ruled that a thermal imaging device is intangible evidence, which would not be permitted under our current law. And we were concerned about the possibility that, for instance, computer data might be considered to be intangible and not obtainable with a search warrant. The other is to obtain a person who's being unlawfully held, since the Garza decision said you can't charge someone with kidnapping unless there's some aspiratation, and the current statute says you can use a search warrant to locate and recover a kidnapped person. We added in an unlawfully held person to say for someone who is the victim of a domestic violence and being held, or in my own case, we had 4 firefighters who were held hostage on a 911 call. Current law would not allow a search warrant to go in and get those guys. We had to use some kind of an exigent circumstance. We wanted to have the ability, because of the definition in 1611-64, to videotape the execution of search warrants by using crime scene text. And the current definition of a private place would not allow a law enforcement officer with video cameras into people's homes without an invitation or without an exigent circumstance because of the definition. And given the support we have for body cams and videos in search warrants, we wanted to rewrite that law. Beginning with the movement of pen registers and wiretaps to Title 17 from Title 16, that is just a wholesale. We made very few substantive changes in what is current law in regard to pen registers and wiretaps. We moved it to Title 17 because it made sense that it's a criminal procedure rather than a substantive offense. We left the criminal offenses in Title 16. The only changes that we made to the substantive laws were, first of all, we defined district attorney so that in the absence of a district attorney, for instance, in my case, I was out on medical leave last year, my chief assistant, as defined by law, could sign an application for an electronic surveillance warrant, and we redefined district attorney and gave the attorney general power to obtain wiretap warrants. Under the Jones case basically said you need a search warrant to install a GPS, or law enforcement needs a search warrant. Private investigators don't, law enforcement does. So we created a procedure for obtaining a warrant. And then finally, we added in a specific section to allow officers to wear body cams, which is duplicative of Senate Bill 154. But we thought we wanted to have a lot of body cam bills moving at the same time to try and get it done, because we believe body cam should be authorized under our law for those agencies that want to use them. We wanted to save law enforcement resources, and particularly since we need to obtain search warrants to get certain types of records, including medical records, we wanted to have district attorneys, investigators who are post-certified, not able to arrest but able to get search warrants of this nature, and also solicitors, investigators. I think the most important part that we added is we added in a change for obtaining what's called stored electronic communications data, which is it's not content, it's phone records, it's cell tower data, it's defined under federal code. And what we did is we took 18 U.S.C. 2703, which is the federal statute which authorizes that, and we added in the requirement that no law enforcement agency can obtain this data without a court order signed by a superior court judge. So what we have essentially done is gone one step beyond federal law, and we have put law enforcement under judicial control before we can obtain your cell phone records or before we can get a cell tower dump, which are becoming increasingly valuable to law enforcement and have become basically a part of almost every case. And we think that it's important that people understand that we're not doing this like the NSA. We're hunters, we're not fishermen. We don't trawl up data. We look for one person, and we think it's important that the public have confidence that it's done with a court order issued by a superior court judge who has jurisdiction over the case. And that's 1611, 64.1, 64.2, and 64.3 that are contained in the revision.
Thank you. I appreciate the detailed summary and the 30,000-foot, intent, and especially in the context of the court cases that have come out that are controlling. Just for clarification for those who may be concerned, I know there's been some discussion externally about thermal imaging and what is and is not allowable under law. Can you just give us the brief summary of where that is, and does the bill address anything having to do with that?
No,
Okay.
Not specifically. Under Brundage versus the state, in that case, the Athens-Clarke County Police Department obtained a search warrant to use a thermal imaging device to look on the exterior of a house, and the court said that that's not a valid search warrant because they were searching for intangible evidence. Since then, there have been other cases that talk specifically about thermal imaging, and we don't have anything in this bill to specifically authorize that. And there are the other cases that are controlling that would probably prohibit searches merely for a thermal signature. And those
I mean,
federal
the thermal signature, that ultimately that's, you said external, but ultimately the idea is to penetrate the structure for internal determination, correct?
Correct. And there's also some concern about there are actually handheld radar devices now that can detect movement inside a house, and there's some concern about those. And this amendment would not. It would put it under a traditional Fourth Amendment analysis that before you can even attempt to obtain that information, you would have to have probable cause to believe that there was a crime going on within the residence.
But there'd still have to be specific authorization in state statute, even allowing for that mechanism to occur
Yes, sir.
if probable cause occurs and if a warrant is secured. But that authorization doesn't exist right now in Georgia law. Is that a correct statement?
I believe that's correct,
Okay.
and that's not contained in this bill.
Okay.
It's not contained in this bill.
Okay.
We're more concerned about computer data, financial records that may be in an electronic format. I guess I could argue that that's somehow tangible, but if we can clarify it.
Okay. Let me ask the Vice Chairman if he cares to give us a subcommittee report.
We've had pretty extensive debate, Mr. Chairman, about some of the provisions in here. I think the biggest concern, which was now removed from this substitute, was a provision related to repealing what I would consider a statutory exclusionary rule for a technical violation of of the search warrant. And they were concerned that I think GACTO, the Georgia Association of Criminal Defense Lawyers, had brought up about the broadness of it, and the author was gracious enough to get rid of that. There was a lot of discussions about the technical difference between a statutory basis for an exclusion versus a constitutional one, under which Leon good faith will apply. So this bill does not. I think it sidesteps that issue, and so. I don't know what GACTO's position is, but it was a level that it was comfortable for the subcommittee members to go. We did put a lot of restrictions back on a couple things related to the length of time in which the government could seal a search warrant for an investigation. Originally was 6 months with another 6-month extension of a year. The members were kind of concerned about the length of which the property, if it's seized, would be deprived, and it would generally be only recourse would be filing a return of property lawsuit without knowing the basis of why they were seizing it. But I think the 60-day was a very good compromise for those parties, and also allowing the government to continue its investigation and maintain the integrity of it. Those are the two big areas. I think the rest of the provisions, and I believe that the members felt comfortable enough that it made sense. It's kind of updating our code to meet the technical changes or technology changes to allow the government to do its job effectively, and at the same time protect the constitutional and statutory rights of potential defendants.
Thank you. Questions for the author, for Mr. Porter, and then after that, I want to hear from the defense bar as well. So, questions for the author or Mr. Porter. Seeing none, gentlemen, thank you.
Thank you.
Ms. Michaels, let me ask you, I assume here on behalf of the Georgia Association of Criminal Defense Lawyers, if you'd like to give us your perspective on the substitute that we have.
Yes, thank you very much, Mr. Chairman. We'd like to thank Representative Administration for working with us. We also worked with Mr. Spadehouse and Mr. Porter. Don Samuel and Jack Martin presented on 2 different occasions their concerns about that section about the good faith. We've agreed to save that for another day, and with 6551 ERS, we're in agreement and have no opposition to this bill.
Okay. Thank you. Any questions from Ms. Michaels?
Thank you.
Seeing none, thank you. I see no one else signed up to be heard on House Bill 430. What's the pleasure of the committee?
Move due pass.
Mr. Strickland moves due pass of House Bill 430 LC 296551 ERS. Is there a second?
Second.
Second by Ms. Ballinger. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed? The ayes have it. The motion's adopted. Again, we went through the exercise of passing this out knowing full well that we're beyond day 30, but I think it's important to have that on the record so that in the event that we do receive permission from a Senate author of a Senate vehicle coming through, that we already have an on-the-record vote of support of the committee, and then we would take it as an amendment to the Senate substitute of Senate Bill X, whatever X is. I just wanted that to be positioned properly so that it can be acted on in an expeditious manner. Is Ms. Chandler here yet? No. So thank you to the defense bar and the prosecutor community for working on this. Bill has been going on for a while, and it's been a lot of back and forth, good clarifications, and it's giving law enforcement the tools they need. But I think there's, like the vice chairman said, there's an understanding and a sensitivity on the balance that has to be struck. I'm not going too far, and it's exactly the way this kind of legislation should proceed, I believe. So thank you to those parties for the work that they've done. Okay, so Ms. Chandler's not here. Well, let's do this. Let me, thank you for doing that. What I'll do is I'm going to have Solicitor Chisholm come forward on behalf of Representative Weldon, who had as I mentioned earlier, he's got an unavoidable client conflict that occurred this morning up in North Georgia, and he has to see to that, and that is priority one. He's here on House Bill 578. And again, we're going to approach 578 exactly as we did on the other bills, and we're going to position 578 potentially, pursuant to the will of the committee, to serve as an amendment to a Senate substitute again at the appropriate time. I think what we actually, let me clarify that, we have received permission from Senator Mullis to amend 578 onto 72, which we'll take up this afternoon. That is contingent on the committee's support of 578 this morning, if that should occur, and that's what the process here is about. So, Mr. Chisholm, thank you for being here, and thank you for your service, and you have the floor on 578.
Thank you, Chairman Golick. I appreciate the opportunity to speak to you today about substitute to HB 578. The purpose of this bill is to modernize our existing harassing phone call statute 1611 39.1. As our current statute stands, it is a violation of law. It's a misdemeanor to repeatedly phone call another person for the purpose of annoying, harassing, or molesting that other person. That behavior still exists today. We still have harassing phone calls, but because of modern technology advancements, that same behavior is also being used with that modern technology. Examples of most commonly are emails and text messaging. So the same behavior is being used in these different form of technologies, and we're trying to close that gap to address that same harassing type of behavior. With me today is Stephanie Woodard, Solicitor General from Hall County, who will be able to talk with you about the effects of not having this language in our current statute, the effects of that on her cases and the prosecution of these types of cases. Also with us today to give some testimony will be members from the domestic violence advocate community to talk about the effects that this gap in our law has on victims of domestic violence. And all of these groups, including the Solicitor General's Association, DA's Association, the Georgia Commission on Family Violence, the Georgia Coalition Against Domestic Violence, and the Georgia Network to End Sexual Assault, that all those groups are in support of this language. I do appreciate Ms. Travis working with us to develop this language. It's the language that we support as is, and also wanted to point out this is the type of statute that a majority of most states, a majority of states have gone to, including Alabama, North Carolina, South Carolina, Florida, and we are in Tennessee. So this is the language that we support as is.
Okay, members of the committee, this bill has not gone through subcommittee, so that doesn't preclude us, again, going to a motion on it and positioning it for a Senate vehicle. But I do want us to take the time, if necessary, to consider ourselves sort of a subcommittee of the whole, given the date. Ms. Tritower.
Mr. Chairman, dealing with domestic cases, I can see where this would definitely be a need. I do a considerable amount of domestic work, and that's where I see a lot of this. I do have a question about lines 33 and 34. Why are y'all wanting to say that it shall not merge? Why do you have to have that language?
We have that language in place because there are some other statutes that are on the books. We want to point out that most notably stalking, that has a computer or electronic communication component, as well as the most recent legislation from last year, the revenge porn bill. We want to make sure that it doesn't conflict or merge with either of those cases or statutes.
So if there was a situation where a judge or prosecutor would allow for it to merge, you're saying you don't want them to have that ability to do that?
I'm sorry, say that again.
So you're saying you don't want to give the judge or the prosecutor the ability to merge this charge in with those charges. Is that correct?
That is the way we have it drafted. Yes, sir. That's correct.
I guess anytime we restrict that way, I don't know. I mean, I understand the charge, and you can bring an individual charge. You can bring the charge against the person if we make this law. But I don't know why you would want to restrict you're taking away some discretion from certain folks to be able to merge this if they need to.
I think I do, I think, and I understand what you're saying, but I think the original intent was to make sure that it was not in conflict with other statutes, and I understand what you're saying now about it. Having that choice of merging, it could potentially, you could have a set of facts that could be covered under harassing communications or stalking, and one could potentially factually merge with the other. So under that circumstance, I think it could merge, but we want to make sure that it doesn't conflict with those two statutes.
Okay.
We had a debate twice on a merger issue as it related to Representative Belton's bill, and the contemplation there was, given the seriousness of the charge, it was obscenity involving a child, electronic, on the internet, which is pretty much forever, and given the nature of the type of offender you may be dealing with, the committee made a judgment that it wanted to make sure that the merger, and the House ultimately agreed, that the we did not want to have merger in that circumstance because we wanted to make sure there was going to be a separate treatment of it, and it would, it'll also, given the nature of it, give the judge an extra year, especially since the first offense on that crime, if I remember correctly, was a misdemeanor. So that we wanted to make an affirmative point that we wanted an extra year for the judge to have and to work with. It did reduce the discretion, and we understood that, but that was a policy decision that we made. That now we're talking about a different kind. It's a very serious charge as well, and the question is, I think, from a policy standpoint, whether we're going to put it in that same basket or not.
Mr. Chairman, if I can, that's really exactly kind of was the point, because we did side on that on merger because of the seriousness of that offense, and this could be, although this is a serious charge, someone's harassing someone, this could not be nearly to that level, possibly. I mean, this has a way of, in Belton's bill, I mean, that if that were the case, usually it was pretty egregious for the most part. I mean, they were purposefully doing those things. Here, I mean, it's just communications. It's just something I thought we'd open up.
Yeah, and I think it's a good discussion. I know we're both careful to understand the seriousness of the underlying charge. I mean, just in the child obscenity electronic communication bill that Representative Belton had, that sort of stood on its own. This I would characterize as being equally serious, but in a different context. Obviously, I mean, anytime you've got a potential domestic violence situation is extremely serious. I think we gave the House Bill 103 some special deference on the merger issue simply because there was a child involved. And then the question, again, it comes down to, in the committee's wisdom, does this, and I hear the gentleman loud and clear, does this warrant the same treatment? That's strictly a policy call, as far as I'm concerned. We'll see what the committee says about it. Yes, ma'am. Please.
About that.
Sure.
So, stalking is a misdemeanor first offense.
Mm-hmm.
Aggravated stalking is a felony. So one of the things we ought to be considering when we're talking about potentially the elements that in both of those crimes is some of the other consequences that come out of stalking, like the psychological evaluation. So if you've got a defendant in one count, and it could be either or offense, and the prosecutor's charged with the stalking, defense where one or lesser included, will then get the conviction of murder kind of situation. So I can't think of too many times other than stalking or the representative standards where representative standards that would fall into this. But and the only thing that I can think of is that I know that stalking, there's some consequences like that in the code that you might want to think about whether it's with murder or not.
Vice Chair.
Thank you, Mr. Chair. I fully support the intent of making this serious. This is a serious crime. But a couple questions, starting with line 28 about the venue, and which related to is kind of what I would consider what the defense would generally argue. The first, in line 30, says it shall be considered been committed in the county where the defendant was located when he or she placed the telephone call or transmitted, sent, or posted electronic communication. I could foresee where, when you have mobile devices, that it'd be very easy to say, hey, Gwinnett County, I was actually in Fulton when I sent that, so you can't prosecute me. That seems to me a problem for the prosecutors. And the second thing is related to this, and this is venue. In line 32, it says the telephone call or electronic communication was received. I understand for venue purposes, but it seems to me that the statute, you'll have a hard time enforcing against someone who's out of state, unless you could somehow.
On the interstate.
Right. If you're in South Carolina and then you're making calls into, Hartwell, I think constitutionally you might have an issue there. I don't know. I mean, I never prosecuted these type of cases. But if the intent was to try to grab people out of state, I'm not quite sure if this language will do it. If the intent was solely to establish kind of where the venue is, then you have an issue of notice. Like if I send you a Facebook message harassing you, I don't know where the victim is. And you're asking me to go defend myself. Let's say I'm in South Georgia. I have to go defend myself for a charge that was brought in, let's say, McIntosh County. I could probably make an argument saying, wait a minute, I had no idea that I was subjecting myself to venue in McIntosh County or whatever judicial circuit that is. Was that kind of discussed with the author in the bill and kind of solving that? Because now we're talking about a felony here. I think we probably need to be more strict in terms of construction of how this statute would be applied.
Maybe I misheard you. It's still a misdemeanor.
Oh, okay. I thought it was.
No, we're still talking about misdemeanors.
Oh, okay. Okay. Even then, I mean, I could foresee if somebody says, okay, well, you have a warrant out for you in a county that you really didn't have any foreseeable kind of connection with. How do we solve that?
I think you're still on notice to, if I'm correct, just because we're crossing county lines, you're still on notice to comply with all the laws of the state of Georgia within the bounds of the state of Georgia. The fact that it's occurring in a different county should not impact any issue of notice, because one county isn't going to be different in terms of its laws than another county unless we're dealing with ordinances, but this is a state statute, and it's going to apply uniformly throughout the state. So I don't think it matters that we're crossing county lines. If you live in some rural jurisdictions, you may not deal with this as much as we do in more populous jurisdictions, where we have people who live in one county and work in another, or have relationships with people in the neighboring county. Seems like to me that we are restricting the prosecution of these cases in the service to victims if we try to limit it to just where it was sent. And then we would also fall into the problem of forcing a victim who might be in North Georgia to have to go all the way down to South Georgia to answer to or testify in these cases, which wouldn't be fair to the victim either.
Okay. Has there been prosecution successfully under the statute?
Harassing
Right.
phone calls?
And any of these issues come up?
That's why Ms. Woodard is here. She's here
Oh,
to talk
okay.
to you about some of her issues that have cropped up in the prosecution of this type of behavior without having this language in our harassing phone call statute.
Thank you.
I'm just looking at the language that we used in Representative Tanner's bill last year to deal with these venue issues. And it's not the same as what's in this bill, but it might be a good alternative if you're uncomfortable with it, because it was the same kind of issue, and y'all approved of that last year. I could read it out loud if you want.
Let me take some more questions, and then we'll circle back anyway on Mr. Strickland. No, Mr. Reeves.
This may be a question that Mr. Porter might be able to help with, or Ms. Travis, but in the terroristic threats felony statute, is there any language similar to this? Because I just recall from prosecuting those cases that the issue of where the threat's received and where it's made, those are contemplated in the terroristic threats cases as well. Is there any language like this in those statutes? Do we know?
You mean venue?
Yes, dealing with. We're talking about where the call was made from and where it was received, and I feel like I've dealt with this before in terroristic threats cases. I'm wondering if there's any language in the statute that lays out the same issue.
I know that there's a computer statute regarding use of computers. I think it's for hacking into computers that has some similar type language as what is being presented here today. I'm sorry, I can't reference the exact code section off my top of my head.
Not a specific venue language in the terroristic threats.
Do you agree that, or am I imagining this, that there are some of these issues are raised from time to time in terroristic threats cases?
I
Mm-hmm.
And you'd have to refer back to the general venue statute where there would have to be a sufficient nexus between
Mhm.
the jurisdiction that prosecuted the case and the prosecutor. And in some cases, it could be that the victim resides there or that received the threat there, or if you could determine where the threat was made, that may be the jurisdiction. Most statutes don't specifically
Mhm.
allow venue provisions.
Okay.
It's in 1721, there's a general venue statute.
Okay. What is that? Does that statute contemplate or overlap any of the venue items we're discussing here today?
Well, this one's more specific. The 1721 allows conduct to be prosecuted if the crime is committed either wholly or partially within the state. The conduct outside of the state constitutes an attempt to commit a crime within the state, or the conduct within the state. The conduct within the state constitutes an attempt to commit in another jurisdiction a crime under the laws of both the state and of the other jurisdiction. And then there's 1722, which is venue generally. And
You
that's-
said -2 is venue?
Yes.
Okay.
17-2-1 is jurisdiction, and 17-2-2 is venue.
Mr. Trammell. Thank you, Mr. Chairman. Just have a couple questions. First question would be on line 16 in the word annoying. Under the present statute, if you call and hang up, that would be annoying. That language makes sense. But it's rare that I go to court where there isn't somebody who says, well, they sent me all these text messages and they don't sort of cross into this line that I would consider that the intent of the bill is probably trying to reach, intimidating or threatening. They're just annoying. Somebody texts a bunch or emails a bunch. And I would guess I would just ask you to speak to that. Do you have a concern about that language? Because the electronic communication devices are different than a telephone. If I send you a text, it doesn't ring in the middle of the night. You can block the sender from sending a message. Could you speak to that?
Yes, sir. Our goal and intent was to stay as close to the original language as we possibly could. This is language that has been vetted for decades now, and there is case law on this particular language so that we felt comfortable with it. I understand the difference in the technology, but I think you're going to find that there will be instances where the texts don't arise to necessarily threatening or intimidating, but they do arise to the level of annoying or harassing. Those you can block messages, but we all know from especially domestic violence cases with persistent abusers, they will find ways to get around the block, and they will continue to send messaging. And my phone does buzz in the night. I can hear it, even though I have it on silent. It does buzz in the middle of the night, and I can tell a text is coming through, and I can't avoid it. I mean, I look on my screen and I see the text, and I can see the content of the text as it pops up on my screen. So it's not as unavoidable as simply not answering.
And another question about that, Mr. Chairman, if I might.
Sure.
But you would agree there's a difference between an annoying text and a threatening or intimidating text or message.
There's a different content to those. Yes, sir.
But this language treats them exactly the same. If you get a annoying text, it's treated exactly the same as if I sent one and I made a physical threat.
That is partially correct. And let me see if I can explain. If the threat is if it is a threat to bodily harm, then it's only one text. That is, I'm going to use text because I think that's what you're using. Only one text is required. Okay, so if it's a threat of bodily harm, then only one text is required. But if it's an annoying threat or annoying type of text, then it's going to have to be repeated.
Let me ask another question, if I might, Mr. Chairman. I would move to line 33. Does any violation of this code section shall constitute a separate offense? and take it in the context of annoying text that we've talked about. And at some point, as I understand, you have to have multiple text messages till you get to the annoying part. So let's talk about this, because this is the type of case that I've had, and I can imagine circumstance where somebody says, this law has been violated. So you have a sender, and they send a bunch of text messages, and the recipient doesn't answer. Does this language mean that every subsequent text after a certain point where court determines or a solicitor determines that the threshold level of annoyance has been met, then is every subsequent text a separate offense? Such as, you can imagine, are you going to answer me? Are you there? Can you walk me through that?
My answer to that is no. That's not the intent. That's not how we treated harassing phone calls. It is evidence, though, direct evidence of the intent behind the texts. We still have to prove that those annoying texts were sent for the purposes of annoying, harassing, molesting, threatening, or intimidating. So the fact that they're repeatedly sent with no response is strong evidence of the person's intent to do just what we're saying, which is annoy or harass.
One final question, if I might, Mr. Chairman. Line 35 about the code section not applying to constitutionally protected speech. What does that carve out?
When we were vetting this language, Ms. Travis aptly pointed out that we needed to be careful of protected speech, especially political speech, like robocalls and political advertisements, which are not just robocalls anymore, but they can come in the form of electronic communicated messages. And so that was a source of focus when we were deliberating on what language to use as part of this bill, and that's why that provision is in there.
I just offer, Mr. Chairman, that and I understand the intent, but constitutionally protected speech seems like that could cover, it might gut the very conduct that you're seeking to address in the bill.
I do understand what you're saying, but constitutionally protected speech does not include that which is meant to annoy, harass, or intimidate or threaten another person. The same argument that you're making could be made for the existing harassing phone call statute. But that has survived constitutional muster, and it was found that there was no due process issues with that statute as written in Constantine versus the state back in 1978. And there's been very little case law on this statute since. So that's why we were trying to stick as close as we can to that bill or that statute. But that provision was added to protect certain forms of free speech, because as much as we're all politicians here, as we like to think that everybody wants to hear from us, I can tell that I do get robocalls, and they are annoying, but you have a right to send them to me, and we don't want to trample on that. So that's not what we're trying to include here, and so we're trying to make that clear demarcation between that speech and that speech which isn't intended to promote or advance any legitimate purpose, which is the annoying, harassing stuff.
Thank you, Mr. Chairman.
Sir, it's good dialogue. Before I pile on to that issue, let me recognize some Superior Court judges in the room. Judge McBurney from Fulton County, thank you for being here. Judge Goslin hiding behind Judge Hamrick, thank you for being here from Hall County, is that right? And then Judge Hamrick from Douglas County, who's here. Thank you all for being here. And again, we just make special note of Judge Hamrick's inclusion as a member of the August class of 1992 of Georgia State University Law School. And I will be introducing him as such every time he's in the room. So we're all clear on that. Mr. Trammell's point's well taken. I mean, I don't know when the original and I realize it's existing language, and that probably inclusion of the word annoying was probably a good idea at the time, whenever that time was. My sense is that the perception on what's annoying and what's not, and the loosely defined nature of the word annoy. Everything from how we in this room define annoy to how the basic teenager may define the word annoy, and everything in between, I think gives us a little bit of pause. Again, understanding its existing law. Harassing, molesting, threatening, intimidating, I don't think that causes any concern in the room.
I will say this.
But annoying
I will
causes
say this,
some concern.
and I'm speaking on behalf of the Solicitor General, as Solicitor General of Athens Clarke County, more so than as the representative of the Solicitors Association. But I don't think any of us will have any heartburn over annoying being stricken.
Well, we're just having a dialogue about it, and I think the dialogue with Representative Trammell was productive in helping us get a fuller understanding of what we're trying to do, and then what we're not trying to do. Mr. Hightower. Okay. And Vice Chair.
One other question.
Yes, sir.
Could someone who has a deep crush on some, object of affection repeatedly text message them, which would be annoying and to the point of being harassment, without being told that that's annoying to them, to the victim? We have like a practical problem here in terms of, as Mr. Chair said, what's annoying to one person or harassing to one person, another person might view it as romantic or something like that. The definition is different. So, as I was thinking about some language, maybe unwanted communication, or something like that would get rid of all the definitions of what's harassing and things like that. If the victim says, "Stop contacting me," and that's a clear line, and then you kept doing it again, and I think it's pretty clear that they would start getting into the purview of the statute. Would the Solicitor Generals be open to changing the language like that?
That particular language that you're talking about, we would not support that particular piece of language, and here's why. Each of these cases has to be prosecuted based on their given facts, and so if you have the type of relationship under the facts that you have described, that would be a very difficult case to prosecute. It would be hard to prove the intent element, and we would potentially need additional evidence. Now, with that said, you could have a domestic violence case where a person who is a victim of domestic violence who leaves the home, obviously doesn't want to have any more contact with the victim or the defendant, and then the defendant sends multiple text messages or emails trying to get that person to respond. That particular case would be one where we would not want to make a victim of domestic violence have to contact that person and say, "No, don't contact me anymore." This very issue, as you have brought it up, was vetted in that Constantine versus the State case. It was a Supreme Court case, and in the context of harassing phone calls. And the defendant in that case made the very same argument that you made. And he said, I've got it, if you don't mind me quoting briefly, it says, "Appellant contends that this language is unconstitutionally vague and broad, and thus violates due process as it fails to give adequate guidance to people trying to be law-abiding citizens, and fails to advise defendants of the offense with which they are charged." His argument was, how do I know that my phone calls were harassing to that person? I don't know, based on the way the law is written, that they were harassing to the person that received them. The Supreme Court said that the fallacy in this theory is that the victim's subjective ideas on what is or is not harassing are not at issue. The point is that the defendant telephones intending to harass the defendant certainly knows if he is doing that. So if you're telling me this is just a romantic request that is repeated, in that person's mind, we're going to have a hard time proving that in that person's mind he intended to be harassing. When he's trying to court somebody, I guess I'm going to use some antiquated terms, but if that's what he's trying to do, I don't think that's going to meet what the intent element that we have to prove in our statute.
Well, I understand that from a constitutional perspective. I mean, you survive constitutional muster. That's like the bottom line. We're talking about policy here in terms of. I understand the objective kind of definition of intent that you need to prove, but it seems to me a language like unwanted doesn't have to be an express "don't contact me" type of thing. You would have circumstantial evidence to prove that this contact would have been unwanted. But my point is, you would clean all the problems that I think that you're trying to address if you had a kind of a clear definition. If there's a reasonable person would be unwanted contact or something like that, then you don't have to get into the definition of annoying, harassing, intimidating. Is bottom line, don't contact me, or reasonable person. If you leave the house, they don't want to be contacted, right? And that's an easy proof. Then the issue really becomes, in terms of why are they keep contacting these individuals, which the solicitor seemed to me have discretion to charge under the statute. I'm just trying to raise the bar so that you're not going to have any additional factual problems when you do that. And I don't understand why you would oppose something like that.
I oppose it because it's requiring victims to make contact with the very person they don't want to make contact with.
Well,
and it's
if its circumstances show that that's an unwanted contact, you don't have to contact them. There's no requirement that they do that. But if they did do that, it would make the case so much easier for you.
It does make it stronger, yes.
So
there's no
why would you oppose to something like that? It doesn't require the contact, but if they did the contact, you have virtually a slam dunk case.
When I get into court and if the statute says unwanted, then the defense is going to be that that person didn't know they were unwanted because the victim never told them that. So it inherently requires, if you use the term unwanted, it inherently requires that victim to affirmatively tell that person, don't contact me anymore. It's not as part of the existing statute. I'm not, and we've survived this long without that type of language. And if we did add this into this particular statute, it would be, excuse me, it would be the only person's crime in the state of Georgia that required a victim to tell someone that's abusing them or committing a crime against them to stop. That would be the only person's crime in the state of Georgia that would have that requirement.
Wouldn't a rape statute be similar to that then? I mean, you have to show that they didn't consent, right?
That's true, but you don't have to tell them no.
Well, I understand that, and it's, what I'm suggesting is
you don't have to fight back.
What I'm suggesting is the same thing. A reasonable person or jury looks at it and said, this is an unwanted contact, then you apply the objective standard. But I don't understand. If the victim says, don't contact me, and some victims will say, don't do it. Mm-hmm. To make the case easier. Oh, never mind. I mean, I guess it's your statute to apply, but it seems to me having some language in there would really clean up the statute, make it easier for you to prosecute these cases. Not make it necessarily hard, but okay.
Mr. Strickland. Thank you, Mr. Chairman. I don't want to be a dead horse. I want to jump at one point there, where the Vice Chairman made. In my understanding of the current statute, though, line 16, where it says the purpose of annoying, harassing, molesting, threatening, or intimidating, what you have to prove is when that person made that communication, they had the purpose of doing one of those things. So I don't know why additional language would be required if you already have to prove that purpose. And leaving it more open like that, I think it makes, as you said, the case easier to try, versus potentially putting a burden on a victim. But I just think the way it's written now, with that purpose language in there, that would suffice to make sure that that person can't say, well, you know, I guess they still could raise a defense. I didn't know I was annoying them, but it's still your job to prove that was their intent. That was their purpose when they made that contact. So I just feel like the existing language would cover your situation, Mr. Vice Chair.
Ms. Ballinger.
I did have a question about juvenile prosecutions. You know, how would that be handled? Could you kind of walk me through that? Because, I mean, there's a big difference, I think, between a 12-year-old kind of being annoying. Unfortunately, we don't just legislate domestic violence situations as much as we would like to. Or much as we would not like to, as the chair prefers. How would that work? How would juvenile prosecutions work?
I mean, it would be handled the same way any other juvenile prosecution would be handled. It's I wouldn't think it'd be handled any differently. I know we have a bullying statute out there to address some of that type of behavior within our public schools, which is going to be more of an administrative policy effect in the public schools, but they would still be prosecuted similarly in juvenile court for this misdemeanor as any other misdemeanor.
So 14-year-olds would be prosecuted without any kind of. I'm just trying to kind of walk through that because I mean, their threshold, is much more idiosyncratic, and I would hate for, a 12-year-old to get prosecuted for a misdemeanor for perhaps being a little too over-amorous or whatever.
And,
I don't.
That would be in juvenile court, and that would not be. Of course, all those records would be sealed. So, I mean, it would be a misdemeanor.
They would still be prosecuted. I mean,
correct. But usually the concern is placing a criminal record on that person.
Yeah.
But like any other misdemeanor crime, we still have to prove all the elements of the crime, and it's going to be a discretionary matter. There are those cases that it's more than, as we established earlier. We're talking about more than just amorous intentions that may go overboard a little bit. This is going to be those types of harassing and intimidating type of texts or emails or whatever form of the communication is that is victimizing another person. And that intent element is still going to be the same in those cases, is my imagination.
But I mean, I'm thinking about, like my son plays football, and what if he's sending another a text to another football player? We're going to kick your ass on Saturday, and we're going to get you, and that sort of thing. I would hate to see him prosecuted for kind of talking smack.
But I understand that.
Because he is meaning to threaten, intimidate, and harass. I mean, that is his intent, but, he's 8 and he's talking about football.
I don't know a prosecutor in the state of Georgia that would prosecute that case. That's just not.
But we don't.
Everybody understands that context.
I mean, I respect prosecutorial discretion, but we make policy decisions. I'm wondering, would it be possible to make an age carve out or something, maybe? To allow for that? No. I have displeased the chair.
That's dangerous. That's really. I mean, I understand.
I mean, I
understand the intent, but that's a dangerous game to play.
Yeah.
That's an eye of the beholder determination sometimes.
Yeah.
On the maturity level of a particular individual.
I mean, I just because that would, as far as my reading of the proposed, it would be captured. That would. Because that is
the dialogue here. We go through this all the time, where we have the words on paper, and cavalry's coming for you. Don't worry. We have these words on paper, and then at some magic point in time, we have to trust discretion. At some point in time, but the challenge that we have is to get the words on paper to the point where we've got it as tight as we can get it, and then we just have to rely upon the elected prosecutor to make a reasonable decision, which they're accountable for, locally. But I think what you're hearing is some discomfort over some of the wording, which may or may not be fixable. I think annoying is definitely an issue. There's just no doubt about it. And I understand that it's existing law. That doesn't matter. The perception is different now, especially with not the advent now. We're in the throes of the technology age, and what it's being used for, not used for, and how it's characterized and how it's defined. Well, one family's characterization of a particular set of communications may be quite different than another. Well, maybe on Saturdays during the fall, there's a perceived exemption, but there isn't on paper, and that's the difference.
Yes, sir.
So we're trying to, we're going to get this to the point where we're comfortable with it. It's an important bill. We're going to move this bill, and we're going to go ahead, I believe, and attach it pursuant to the permission that Senator Mullis has given us. But I think we need to just take another quick look at it and clean it up and get it to a comfortable place and move it on.
Respectfully, and for Representative Ballinger's point, I wish all 8-year-olds were parented as well as I'm sure yours is. If there's under our current juvenile system, I don't believe it would be prosecuted. With the children in need of services aspect, there's an extra filter. There are a lot of chilling participants in this process before we ever get to the jury trial. There has to be someone who's annoyed or threatened or intimidated or molested enough to make the report to law enforcement. Law enforcement has to perceive it with a probable cause to make an arrest, and then it has to vet through the prosecutor's system. Solicitor General Chisholm and I are no longer haven't been in juvenile court for a long time since this body changed the system. But it would not currently automatically default to prosecution under the system that's now in place to protect a aberrant, overzealous little league football person. I'm absolutely positive. The 3,000-foot view is we have an antiquated. You have to not hang up the party line. You have to not. You have to not hang up on the end of a call at a time when technology existed that could cripple communications. And our communications have come so far that I'm asking this body not to fail to protect victims who are being harassed and intimidated. We've got to leap forward at least into this contemplation of technology. The venue aspects will be filtered through a reasonable person standard. I can tell you that we had 23 cases in Hall County last year that were only brought because of the intent that I could see behind the relationship. Unfortunately, I'm forced to upgrade to a stalking, which the statutory language there contemplates specifically where the person's at, and a surveillance mechanism that jurors see isn't part of the meaningful harassment. Not all victims have the technology to be able to block an incoming call, so they can't decline that call as the iPhone allows me to do, but not everyone has that technology to be able to. And we've gotten repetitive not guilties because it sits in the language between this antiquated telephone statute and doesn't rise to the surveillance aspect and location orientation that the stalking language has. Respectfully, I would love for the annoying language to be there, and I speak to high school seniors all the time about realize that the jurors in the box aren't necessarily fellow 18-year-olds that think 200 texts is a conversation. They may be old fogies that think that's annoying, but respectfully, we don't bring those cases. I do, however, look at the 17-year-old who sent 4,000 in an hour and a half. And respectfully, if that was being received by a member of your house, I promise you would find that annoying. It may not be meant to intimidate. It may not be meant to harass, but there's not a legitimate purpose. And that's the language, that's the type of behavior that we're looking at in the annoying aspect as well. This is a statute that covers everything from very serious domestic violence to some behavior by folks that have no legitimate purpose that crosses the boundary.
I understand where you're coming from, but you just said it. I mean, somebody in the box may think that's annoying. Somebody in the box may think, well, that's that's SOP in our society. The very divergence of opinion on something as simple as that, having an eye of the beholder determination on what it is and what it isn't, depending on what generation you may be, and it's a criminal statute with a criminal charge. I don't care if it's sealed or not sealed. It's there somewhere. That's going to haunt that person for the rest of their lives, potentially. And so, I don't think anybody's talking in the context of a complete rework of the statute, but we can't just ignore the breadth of the potential definition of annoy. We just can't ignore that anymore. So I hear what you're saying, and I trust you, but you're not going to be around forever.
Yes, sir.
And neither am I. And so we don't know what the future brings. And we, what I love to be able to say, oh yeah, they'll use common sense. I'd love to be able to promise myself that. But I know I'd be lying to myself. Because somewhere, some cowboy is going to go ahead and try to get a cheap headline on conduct that is annoying, yeah. Is it really criminal, though? Nah. Well, but we'll do it anyway. We'll do it anyway, and we'll just see what the jury says. Don't care about how that affects that particular person. Maybe it's a teenager. Maybe it's not. We can't throw I don't think we can. Personally, I don't think we can throw the dice on that. We can go ahead and afford a lot of discretion, but when you've got something that's so utterly amorphous as the word annoy, it begs a conversation. We'll see what the committee thinks. I have no idea. They've surprised me before. and they will continue to. And as we have this conversation, it's becoming a lot more illuminating to all of us. What are the risks that are really involved in it? We trust you, and we trust you, but we don't know what the future brings, and that's how we have to go ahead and legislate. So, and we've been going through this struggle for years. Discretion, discretion, discretion. And by and large, we err on the side of discretion, and we're wise to do so. But when you've got something that's so utterly ill-defined, I don't know that we can comfortably do that. Mr. Setzler.
Hey, Mr. Chairman, I was asking the question, and perhaps it was explored some before I got here, working through the same things. The code section shall not apply to constitutionally protected speech. We have the obvious cases before us that we want to be able to for sure prosecute. You've got the cases that should be out of bounds. How does the constitutionally protected speech work? Is that a standard that's off applied? If I've got a parent that's has a 19-year-old daughter that goes and moves in and lives with a known drug user, and parents are sending communications to this 27-year-old drug user about staying away from their daughter. We've told, I can see there being some intense communications back and forth. I say drug user. I don't mean someone that's convicted, that's so forth, but someone that's maybe has a history of that. If parents are in communications with another entity, another adult, in familial relationships and those kind of things, where I would argue it's appropriate. If there's a 19-year-old young lady that's a recent high school graduate that's living with a 27-year-old with a criminal record, that there could be some very aggressive conversations between parents of the girl and the 27-year-old. I can see a 27-year-old saying, you know what, they're harassing me. They're trying to intimidate me to leave their daughter alone. I'm going to bring a case against these jokers. I want her parents to I want the courts to rule that her parents have to leave their 19-year-old alone because they've been emailing me, they've been calling me. They're trying to find their daughter. She's an adult. She can act for herself. Those are the border conditions that I'm not trying to create, unnecessary controversy in the committee room, but those are circumstances where you could have some intense communications going on, and I certainly wouldn't want to allow people to not advocate for others. How does the constitutionally protected speech protect that, or is there another setting where that fact pattern might be, appropriate?
I'm going to defer back to the way the statute is written. The statute is written, you still have to go back and prove that they sent those communications for what the purpose was. Was the purpose for harassing them, intimidating him? And it also depends on the context of those cases. You better leave my daughter alone, or else, and then there's some type of threat. Yes, that's a crime. That would be under the harassing communications. You can't do that. But if the communication is, I'm worried about my daughter. Where is she? Is she being taken care of? Will you please call me back? I'm worried. If you read the context of those statements, they might be repeated. They might be annoying or harassing or something to you. I'm not saying that you were the person that was acting as the drug user in this case, but they might be annoying to that person. But that's not a prosecutable case under those facts.
Well, under the way you described it, obviously there's a kind way that someone could speak that the court would clearly say that's not harassing or annoying communications. The way you said that, if you said it in a gentlemanly way, it's not. But if you're in a passionate, perhaps appropriately passionate and forceful way communicating things with people, maybe he brings a case and the prosecutor says, nope, not going to prosecute that case. Have we created a right of action where he says, well, you know what, he violated this law, I didn't win criminally, but I'm going to go to a court, I'm going to sue this guy for this, and can I convince a court 51-49 that he ought to, is this enough to get a civil action against this person for this fact pattern? I wrestle with those things. I'm not trying to keep you from doing what you need to do. We understand we have to update the law from telephones of the 1980s to text and electronic communications in 2015. But this bill isn't limited to just telephone to text. It is broadening the definition some, and I think I certainly need a level of confidence that we're on solid ground. That's.
And respectfully, we can all come up with fact patterns that would cause us concern. That's simply not the case, or the cases that we're being brought. And I'm asking you not to fail to protect the victims and the number of victims that were being brought, because we can imagine those circumstances. We will litigate those issues. There will be a level of discretion by law enforcement, by prosecutors, by courts, and there is continued evolving. But I'm asking this body not to fail to move into the broad place that we need to be, and that is creating that protection for victims.
I mean, I hope I may not have been clear earlier. We're not contemplating that. We understand the electronic communications technology. We've got to go ahead and have the statute envelop that conduct. We get it.
Yes, sir.
So that's not, my sense is that's not going to happen. It is going to happen. But we just have to, I think there are legitimate questions on the venue piece, and there are legitimate questions on the annoy piece. But that doesn't mean that we're not going to go ahead and take a look at the higher level, priority, which I think we'd all agree is important to go ahead and make sure we catch, and especially now. We're behind. I mean, we're surrounded by states that have acted on it. We haven't. So there's an imperative there, and we get that. Judge McBurney, I saw your name is signed up here. I don't know if that was done with your permission or not, but I saw your name, so I wanted to make sure that that if you wanted to be recognized, we wanted to do that, and if not, you don't have to.
No, I would like to.
Okay, please come forward.
On behalf of the Commission on Family Violence, as the Vice Chair, and I know the Chairwoman did get a chance to talk with you, but I thank you, Chairman, for having me here.
Let me ask you a
All right, I'll just slide up a little bit. But I do want to address some of the questions that arose wearing the hat in part as a judge, but mostly as the Vice Chair of the Commission on Family Violence. This is a necessary and valuable revision to existing law. It's not making new law, it's revising existing law. It's valuable because of the do not merge provision. As a judge, it gives me more flexibility if crimes don't merge, because then I have the ability, if I need to stack the offenses. But I can always, if I think they're sufficiently similar and the case isn't particularly egregious, run the sentences concurrently. So the ability to not have something automatically merge, I think, is a tool of use to prosecutors and certainly to judges. It gives us more pieces to play with. And if we want to run them concurrently, it's effectively merging them. And it's a misdemeanor, so it wouldn't amp up anything that started out as a felony. It's valuable because of the venue provision. It allows the case to be brought where the victim is. And wearing the Commission on Family Violence hat, this is something that helps victims of family violence who, unless their abuser is using a rotary dial phone, basically they have no protection from, and let's leave annoying off. I think that's right, to not get bogged down in annoying. Harassing communications, threatening communications, etc. It's the text, it's the emails. It's nowadays you can broadcast something far and wide to humiliate and shame and try to control your victim in the form of an electronic communication that's a post on a Facebook page that is to your victim, but you can let everyone see what it is you're saying about your victim and harass your victim that way. Not covered by the current law, but if we amend it in the way that is envisioned, we get that protection for the victim. And with the venue provision, which is simply saying this, it either is prosecuted where the sender sent it or the recipient received it. And there's nothing particularly controversial about that. In a murder case, if bad guy shoots someone in Fulton County and the person drives all the way down to Chatham County and dies in Chatham County, you can prosecute that murder in Chatham as not controversial, it's not unconstitutional, it's how the law works. And all we're doing here is empowering the victim to have that prosecution brought where she or he is, rather than having to travel to where the offender is. And it's also a valuable statute because it does not require a response from the victim. And I appreciate Vice Chairman Pack's concern about simplifying and saying unwanted communication. Harassing, molesting, threatening, intimidating are all unwanted communications, and that's how we should leave it. It puts the focus on what was the intent of the abuser, of the defendant, of the person making the communications. And we don't shift the focus to, well, what did the victim do to say no? That's not what this crime is about. And if you shift it in that way and put a burden on the victim, this isn't something that the Commission supports, and it's not something that protects the victim because it requires them to engage in the very person they're trying not to engage with. Last thing I'd say in terms of the concern about juveniles, kids push kids all the time, and we wouldn't take assault or battery off the books either. It is, in some respects, you do need to trust the discretion of the prosecutors, the judges, etc. This is something that is of extreme value to the domestic violence community. An entree for someone who has been kicked out of the house or for the victim who's left, an entree for that abuser is to pester and harass and intimidate until someone texts back, and then they figure out where that person is. And I'd ask, although it's your discretion, Chairman, that you recognize Jennifer Thomas, our executive director, who can actually give voice to people who have died because they responded to the harassing communications. I mean, that's how real this is. And I'm mindful of the concern on one end of an angry dad who says, "You touch my daughter or else." And that happens without phone calls, and that's a terroristic threat. If the daughter is standing next to the gentleman who's threatened, "You touch my daughter, I'm going to blow your head off," that's already a crime, and it wouldn't be prosecuted, but we need to be thoughtful about that situation. The core focus of these revisions are for the victims of domestic violence. I appreciate everyone's time.
Judge, on the merger issue, that I assume what you're saying is, and we've seen this again in other legislation, you're advocating for the tool of having that potentially increased supervision to get that extra year of
Correct.
whatever it may be in the event you have an offender who maybe needs that extra eyeball for an extra amount of time. Is that right?
Exactly.
Okay.
The harassing communications typically would arise with other misdemeanors, and maybe there's a family violence battery and a harassing communications. The longer we could extend that supervision and that condition of staying apart, that's not just a protective order that could expire or would require a victim to have to return to court, the better in many, many situations. And by not having merger with stalking, and I agree with Solicitor General Chisholm, there aren't many potential mergers out there, but the ability to avoid the de jure, by law, merger allows the prosecutor to seek and a judge to grant an extended period of supervision. Again, we're talking about a misdemeanor in the end, so the stackability effect isn't, well, we can add 5 years to your sentence. That's not the point. We are dealing with months rather than years, and the addition of 12 months can be extremely valuable to allow a victim to establish herself or himself in a new setting away from the abuser.
Let me ask you about, thank you for the response, on the venue piece, you've got with the telephone call, looking at line 32, the telephone call or electronic communication was received. We touched on, it may have been before you came in the room. Now, what if they're, again, this is half the job here is trying to crystal ball the what-if scenarios.
Right.
What if the victim is on I-85 heading up to Lawrenceville to celebrate Mr. Porter's birthday? And,
and that's a large group.
And, yeah, and, and then... That's right. There's a caravan. That you've got, the first phone call comes in Gwinnett County. The next phone call comes, the repeated phone call comes over the county line. The next phone call comes, talk about the functionality of that when looking
Sure.
in the context of received.
It's a continuing offense.
Yeah.
And so in theory, it could be brought once the repetition has begun. So if call 2, if that's enough. And
So it's pick the venue.
It's pick the venue. It could work that way in the same way that someone could be kidnapped and escorted, moved across a number of county lines. Well, the kidnapping is occurring throughout the movement across those county lines, and it could be that while the person's going across different county lines, there's beatings that are going on. I mean, in the same way, you could create scenarios for many other crimes where there is a sufficient nexus in a jurisdiction. I think realistically, your victim is going to want to have it prosecuted where he or she resides, which is typically where those communications would come. You could have someone who works in a different county than where she lives, and maybe the harassing comes only at work. So you could have that scenario. But I believe that that provision would allow venue in either where it was sent, or I think it may have been Vice Chairman Pack's point that the sender could be traveling along, and you'd have that possibility as well. Of course, a defendant could always argue sort of a forum non-convenience argument that it's crazy to pick this one phone. I made 99 phone calls to McIntosh County and 1 to Butts County. Why are we in Butts County? And a judge would have to work through that. You don't seem satisfied with that answer.
No, no.
My
I'm just.
request would
I'm
be
trying
this.
to. What we're trying to do. Half the battle here is just trying to make sure the practical realities are addressed. But that's just part of the process. But
Sure. The value, as it is worded now, is that the case could be brought where the victim is, and if there's a way to preserve that feature, but tweak the venue language so that it doesn't give rise to the concerns that you shared, the commission wouldn't oppose that. But again, much like it doesn't require an affirmative rejection from the victim, stop sending me these things, the ability to bring the case where the victim is rather than where the harasser or intimidator is something that the commission values.
Okay, Mr. Pack.
I don't think any member here are saying that let's not think about the victims. I think probably because the way the language is currently is because we thought about the victims. Question, with the definition, if you go to trial, what is the jury instruction defining the purpose of annoying, harassing, or molesting? How is that defined?
I didn't bring my jury instructions. We have some fashion for the last time that we prosecuted a landline harassing phone calls, and we still do give them. But we incorporated a plain English Webster's dictionary into our jury instructions there. So I can ask for that to be sent. I just don't remember it by heart.
And setting aside annoying, because it may well not survive, and the commission doesn't have an issue with that, I think that's the right answer. It's the plain English definition. You would want the 12 reasonable jurors to determine, was the purpose of this stream of communications, in whatever form, for the purpose of harassing or molesting or threatening. That's when you look to the content of the communications. I mean, that's what the litigation that has made it up the chain has been about.
What about repeatedly? Is that 2?
That's a jury question as well, but I've never prosecuted a case that was under 75.
That gets us right back to
We trust you. We don't trust
it
your.
gets us
we
right
don't
back
trust your
to
successor.
We get it, but we have to think about what the words actually mean in terms of the King's English, and
Well, when you're looking at, you've got to look at the reality of life as well. I mean, you don't want to. I promise you don't want to do a bright line rule that's an instruction book for abusers.
Call 9 times.
Right.
I can call 9 today and 9 tomorrow. And
Sure.
9, and there has to be some amount of interpretation in every statute that we have.
I don't disagree with that. I'm just looking to see if there's a more artful way to narrow it. That's all we're doing.
We've had some wonderful conversations because there was a word successively was mentioned. And the problem with that in the plain English is it requires repetitively without interruption. So it's a tough word to play with, and repeatedly comes back to the common sense multiple times with the purpose language.
Follow up. One other thing, I noticed this, I think, when Representative Trammell was asking this question. If the crime in line 14 says repeatedly, and in line 33, 34 is a separate offense, so for each text message that you send could be a separate count. So in situation, you're saying that that person committed 75 counts violation of this statute? Or is it just one under subsection 1?
We charge 1. If there, I can tell you where there's if there's an activity.
Isn't that multiplicitous?
Excuse me?
Well, if it's the same crime that you could charge as a separate crime and you put it into one crime, isn't that multiplicitous?
Well, if there's a natural grouping to the behavior, where we've had people make repetitive calls on one day, some lapse of times where we can see where we can break it into separate offenses. That's certainly something that we consider because we never know what the proof issues are going in. But I wouldn't do 75 counts off of one continuous stream.
Okay. Okay.
Fair warning, we're going to take a few more questions. We do want to squeeze in Representative Chandler's bill before we adjourn. We certainly don't have to go right to noon, and we're going to try not to. So, members, let's make these questions brief if we could, and the responses as well. Thank you. Mr. Setzler. and we'll come around.
Appreciate you being here today. Appreciate your detailed layout on a number of these things. How would you, in your courtroom, interpret constitutionally protected speech? Could you speak to that provision for me?
I will. I think that provision gives comfort to some, but it's surplusage. A statute can't abridge constitutionally protected speech. And so if the language gives comfort to the committee should leave it in. But I promise you, no statute you pass can abridge constitutionally protected speech. And so we would run into, whether that language is in there or not, the scenario you described and how to wrestle with it. But you can't criminalize that which is constitutional. You can try, but then a court will unwind that. This doesn't do that because you don't have a constitutional right to harass or intimidate, etc. But as I understand it, adding subsection E was something that did give comfort to some folks, and it's great to have it in there. But that's where we are with constitutionally protected speech.
And I'm sensitive to the chairman's timeline, so I don't want to belabor the point. If constituents email their state representative 75 times saying, if you vote for HB1, sponsored by the gentleman from Smyrna, we're going to take you out. Your political career is over. That would seem to fall into constitutionally protected speech because it deals with politics. What are the borderline cases there? I wrestle with this. Clearly, every issue there's inbound things, there's out of bound things. What would you call the borderline? Could you give me one borderline condition in your mind that would fall in that gray zone of constitutionally protected speech?
Sure, it would depend on how the person said we're going to take you out. We're going to vote you out of office. You need to keep receiving those emails. But I know where you live. That has nothing to do with you being an elected official. It has to do with your safety. I know where you live, Representative Seltzer, and that's the kind of thing where if that's repeated, I think it falls under this. And there's no constitutional protection to cause you to feel uncomfortable, not for your political career, but for your safety. But it could be interwoven with, I can't believe you took that stance on Bill X. If it evolves to, or I know where your daughter goes to school, then you're going to write that email back saying, well, you've got another thing coming, and make sure you don't run afoul with the statute.
Thank you.
Okay.
Mr. Strickland.
Thank you, Mr. Chairman. I just want to point out, for the committee's sake, and deal with the issue of venue. I was looking at 17.2.2 right now, and Section E deals with a crime that's committed while in transit in a vehicle, in a rail car, and it's already very vague. And you actually already have multiple possible forums for venue right now, because it says that if you can't readily determine where the crime occurred, then that crime occurred in any county in which that railroad car, vehicle, watercraft, or aircraft has traveled, any county in which it traveled through. So you already have an existing law, a lot of flexibility as to where venue would be. So I do think that is consistent with the language we have in this code section here, with this bill here.
And if I may, we have the ability to pick, but it's one and only one. So we don't get a try in Athens and a try in Gainesville and a try in, we pick one and only one.
From a practical standpoint, really line 32 is going to control, because if you've got somebody, moving on down the highway, you can't, the practical realities of proving where that is not going to happen. It's going to be where the victim got the call.
Well, it depends.
Or the calls, right?
If DA Porter is able to get those cell phone records pursuant to the other bill that was considered, he might be able to pinpoint where through the cell tower the person was. But in general, I think you're right.
I mean, why go through all that when you just get it under line 32?
Yep.
Okay.
Right.
Ms. Ballinger.
I just had a question. Because we're broadening, any other form of electronic communication, but there's the word repeatedly in there. How would that be dealt with as far as, because there's no, we all, as politicians, we have, we communicate with our constituents via email, Twitter, but there's all these aggregate apps that allow you to blast something out on your Twitter feed, on your Facebook, on your Tumblr, on Instagram, that sort of thing. So would that constitute repeatedly or no?
I'm not familiar with the app, but if I go based on what you're telling me, and I know that the app will, if I send it once, but I know that the app will keep resending it
will
over
ding. If I wanted to ding Representative Pack, I could do one. Basically, I'm only performing one act
Right.
But I'm communicating with him 7 times.
But if I know that I'm committing that one act that will result in 7 contacts, the contacts being
so
meant
I've
for the
committed
purpose-
repeatedly at
Right.
that point.
My position as a prosecutor would be repeatedly. I think there's an argument for that. If I knew that that's what I mean, presumably you get the app that's meant to repeat something to someone multiple times. It's going to probably be over a period of time.
Just different mediums. So it would be kind of one message, but over different mediums. So it would appear on his Twitter feed, on whatever. It would message him, that sort of thing.
To me, that's
so that one act.
That one act, in my opinion, the reason for that is it's to make who I say his. It could be his or hers. Attempt to contact somebody with harassing type communications more easy, as opposed to, well, this is a lot easier than getting on sending an email, sending a text, making a call. So I can do all of that with one type of app and accomplish the same thing. So in my opinion, that would be repeated.
Yeah, it's kind of one of those eye of the beholder things. Is that, I mean, it could be comprehensive communication, like, hey, I really need to know when that meeting is, or it could be, harassing. So I don't know. Anyway, I just had that question.
Mr. Hightower.
The concerns that I have are really what Trammell and Pack have said about these. I understand that you're waiting until 75, but the way this is worded, you could possibly do that, and none of these offenses would merge. And Judge, to what you were saying, first you said you cannot criminalize that which is constitutional, and I would love for you to come and help fight for some of our gun bills on that topic, but that's on a separate note. But anyway, the way we looked at Belton's bill, in my opinion, we didn't want that to merge because we looked at that as being the high offense. We looked at that being the charge we didn't want to lose necessarily. But here, I believe that from what Ms. Travis was telling us, stalking has other requirements that are going to be attached to if you're found guilty of stalking. And right now, I'm trying to think, and I was even looking through the code on my phone to see where else it may be merged. I'm not sure. There could be others, but stalking may be it. But if it is just stalking, use that. This would be used for someone to step down. You would still not lose this charge. Where in Belton's, we didn't want to lose that charge. And in your example, when you said battery in this, in order to sentence a person, have discretion to add more months or not, I don't think this would merge with battery. You'd still have this. In your example, you wouldn't lose this charge in your example. So I don't know if that example would really work. But in stalking, if you had a stalking charge and you weren't real sure about your stalking, you could merge it into this. You're not going to lose this charge.
To use your example, in a situation involving domestic violence, the ability to double the length of the period of supervision from 12 to 24 months is extremely valuable. Sure. By having no merger, you could do that if you have stalking and harassing communications. If they merged by operation of law, you couldn't ever do that. And so that's why I'm saying it's a value. You're right, battery, and that was an inapt comparison, but you could double the period of supervision, give them 24 months to cool off and move apart. That's hugely valuable. If they merge, you'd never have that opportunity.
Only if, and really, but only in the context that we can think of in stalking charges with this. In all other contexts, it wouldn't merge anyway. So that.
But what we see most typically is that this arises with a stalker. It's someone who is making unwanted contact with the victim. And so these charges very frequently would come together, except they can't because they don't harass by way of landline. They harass other ways. And so you have to use stalking as your default.
And to be honest, the stalking merge, that really wasn't the big part that I was getting hung up on. It was the repeatedly. And not having those prosecutors that don't use that discretion as well as others, and you're looking at someone who has 75 charges, because I understand that you would probably use your discretion very well, as would most of those that come and testify before us, but we do have those that we know that do not use that discretion quite as well. And that's where the concern comes in.
One thought with subsection D would be to not have the phrase a separate offense and, well, let's get a few more words, but the point is it shouldn't merge. But I'm not the author or the proponent of the bill, but that is confusing wording in subsection D. And one of your colleagues raised that as well. Would it be 75 counts or 1 count? And we appreciate the discretion that you give to prosecutors and judges, but the value I was highlighting was the merger piece and not the, could I bring 27 counts of harassing communications based on 29 calls? I think that would be misusing the statute.
Thank you.
All right. I think we're at a point where if we want to quickly address Representative Chandler's bill, we do well to go to a motion and entertain potential amendments on House Bill 578. So with that, let me ask, what is the will of the committee? Mr. Setzler moves due pass of House Bill 578 by substitute LC 296564S. Is there a second? Second by the Vice Chair, Mr. Pack. Are there any amendments? Mr. Pack.
In line 16, I would like to strike the words annoying and the comma right after it.
Mr. Pack moves the amendment on line 16 to strike the word annoying with the comma next to it. Is there any objection to the amendment? I should ask, is there any discussion on the amendment? Seeing none, any objection to the amendment? With that objection, the amendment is adopted. Are there any further amendments? Mr. Setzler, did you have an amendment? I see your light. I wasn't sure if that was from before or not.
Yeah, Mr. Chairman, I was just making a motion to do pass.
We have a motion already on the floor on the pass. So, and we have the amendment. Do you have another amendment?
I think there was some question about the merging piece. I don't know that I'm. No motion, Mr. Chairman.
Okay. Are there any further amendments from members of the committee on House Bill 578 by substitute? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion to move by substitute else of HB 578 LC 296564S. All in favor say aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you all for your help.
Thank you, Chairman.
Thank you.
Let's move to House Bill 534. Representative Chandler, Ms. Ballinger, you can do it right from there. Is fine. Don't worry. I appreciate that though. Ms. Chandler, Representative Chandler could not be here today, so Ms. Ballinger has graciously accepted the responsibility to speak to House Bill 534. Hopefully, a pretty straightforward proposition. Ms. Ballinger.
Mr. Chairman, if they will close the door.
They'll come.
I bring before the committee House Bill 534 on behalf of Representative Chandler. We are working from LC 296503, a fairly straightforward bill. It would just basically add under the grandparent and grandchild the whole blood or half blood to both grandparent, grandchild, aunt, niece or nephew, uncle and niece or nephew to the incest statute.
Let me ask counsel if I could. We don't have any definitional issues someplace else on the with regard whole blood, half blood. Well,
I think he's wondering, is whole blood or half blood ever defined in the
we
code?
have other definitions someplace else that would conflict with how we're defining whole blood, half blood. Okay. Mr. Sefton.
I was just going to make the tongue-in-cheek remark that I see an LC 29 at the top of the page. I'm quite sure the lady is happy with all that. Which, no, didn't we take this up last year and address this?
I don't recall.
Okay.
I don't recall it. I just want to make sure we didn't have any definitional conflict someplace that was unanticipated, but apparently we don't, and that's a good thing. Any questions for the sponsor, Ms. Ballinger? Okay. What's the pleasure of the committee? Mr. Setzler moves due pass of House Bill 534, LC 296503. Is there a second?
Second.
Second by Mr. Strickland. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion's adopted. What we will, and thank you, Ms. Ballinger, for handling that. What we will end up doing, assuming no problems occur between now and 3 o'clock, is when we consider Senate Bill 72, we will seek to amend with the author's permission House Bill 578 and 534 to Senate Bill 72, and we'll reconvene at 3 p.m. and we're adjourned for now.